Katarina.
Thank you.
The view from Croatia.
Yeah, I'll provide a view for a Croatian perspective of the cartels and leniency in cross-border setting issue. In order to make some room for discussion afterwards, I will shorten a little bit because everything, a lot of things were already mentioned. I'll just guide you through the, if I may just have a pointer mic, please.
Pointer.
Thanks. I'll guide you through the legislative framework that is applicable in Croatia, novelties that were recently introduced by the recent enactment of the new Competition Act, then something about the cartels and applicable fines for the infringement. We'll continue with the case law, leniency, what is new on the horizon, whether the leniency in Croatia is an effective one or maybe not. Then we'll touch base on the cross-border cartels, mainly issues that have already been covered, and then we'll strive to provide something that will be instead of a conclusion. Recently, in July 2009, we had a new Competition Act. It was enacted, came into force only on 1st October 2010, so it had a rather long adoption period for it. In addition to the Competition Act, there are various regulations applicable to the various matters at hand, including that on setting of fines and that on leniency programs, both of which are applicable as of 27 November 2010. All, as you can see, rather new pieces of legislation. In addition to purely local legislation, we also have the Stabilization Association Agreement in place, as the Ambassador Van Doren already mentioned. The Competition Act itself calls upon the application of the criteria of European Union competition law when you find yourself in a situation where you have lacuna or uncertainty in application of a law. The Stabilization and Association Agreement itself sets the rule under which the criteria arising from the application of the competition laws applicable in community should be applied in Croatia as well. This approach has been confirmed by a recent Constitutional Court's decision, where the court held that the Stabilization and Association Agreement should be viewed as a grounds for interpretation of Croatian competition laws. It also held that the harmonized legislation is to be applied in accordance with the meaning and the spirit of the acquis. So, as we can see, we have the setting for rather good competition law regulation. As I said, the Competition Act that was recently introduced brought some novelties. Previously, ineffective two-tier system has been abolished. The system was essentially having the agency establishing the breach, whereas the local misdemeanor courts were those that have levied the fines. As these are the courts that usually deal with, for example, traffic cases, you can imagine that this was a rather non-effective system. You had the administrative court ruling on the legality of the agency's decision, and sometimes misdemeanor courts waited for the administrative court to adjudicate on the issue, which caused sometimes statute of limitations to lapse, and then effectively cannot do anything. Or the misdemeanor courts would generously apply various mitigating or other circumstances and reduce the fine. So we can all agree that this system was not effective, something had to be changed. So the new Competition Act introduced the novelty where the agency is now empowered to both establish the breach and levy the fine. The administrative court still is responsible for reviewing the agency's decision, but both on the substance and on the fine. There is another novelty that fines for individuals have also been abolished. So now you have only a fine for undertaking. Investigative powers of the agency have been broadened. The donor rate rules have been introduced. As already mentioned, the competence of the administrative court has been broadened. It resolves in an expedite procedure, and the claim lodged before the administrative court has a suspensive effect. As regards the rules on cartels and applicable fines, we do follow rules applicable in the EU. The Article 8 of the Act governing the cartels fairly corresponds to the Article 101 of the Treaty on Functioning of the European Union. The fines, infringements of the cartel prohibitions are fined by fines which is set at up to 10% of the aggregate turnover, so again something similar as in the European Union. And the detailed rules on setting on fines are contained in the regulation, which is fairly modeled on the Commission guidelines. It's basically made as a two-step procedure where the agency first establishes the basic amount of the fine as a first step and then applies either aggravating or mitigating circumstances which either increase or reduce the fine.